We got it. Great. This is the meeting of the Judiciary Committee's Civil Law and Procedure Subcommittee. And it is what 3-5 at 11:35. We actually it looks like we added a bill, but we're going to take a bill off. So we actually are going to go even. Let me just close my door because I can't hear. All right, so I'm going to start with House Bill 693. This is I believe this is the right, no, that's not the right bill. House Bill
698.
698, thank you. House Bill 698. This is Delegate Bartlett's bill, and she is putting in a letter to the chair to withdraw the bill and think about doing things a little differently. Is there a motion on this?
Move unfavorable.
Move unfavorable, withdrawn, right?
Withdrawn.
Okay.
Second.
Is there anybody who opposes the unfavorable and withdrawn on this bill? Great. We are, and we do have a quorum, do we not?
You're fine.
Just 2, 3. Yes, Holly, we have a quorum. Okay, good. So we're done with that bill. Perfect. Let's move on to the House Bill 359. Since we have Mr. Enton on, do we have Delegate Long on? If we don't have Delegate Long on, maybe we'll wait for a minute.
I'm sorry, what's the bill number?
359, House Bill 359.
Mr. Chair, I do not see Delegate Long.
Okay, so we'll hold off. I sent him a link. You know what? Let's work on it. I think that we have 2 amendments on this bill. The first, there were some issues that the bankers had. Is that correct, Mr. Enton?
Right. We had 2 concerns. The bill provided for a stay in a foreclosure proceeding, and we worked with Delegate Long on 2 amendments. The first, and it basically said that the guardianship proceeding could stay the judicial proceeding. The judiciary filed written opposition, saying that they thought that if there was going to be a stay, that stay should be determined by the judge that was hearing the legal proceeding. Delegate Long agreed with that, and so the First Amendment just makes it clear that any request for a stay would be in the pending civil action, the foreclosure action and the other actions. The Second Amendment that we discussed with Delegate Long, which he agreed to as well, was that the bill would be prospective. Just to make it clear, the bill wouldn't apply to proceedings, whether any of the civil proceedings that were listed that were filed prior to the effective date of the act. With those 2 amendments, Maryland Bankers Association is fine with the bill and has no concerns.
Yes, Delegate Williams.
Yes, thank you, Mr. Chair, and thank you, Mr. Enton, for being here. I have the one amendment, the one starting 363-125, but I didn't see the Second Amendment, which was described going prospectively, which I know was in the testimony from the Bankers Association, but I didn't see the Second Amendment. I just wanted to see if maybe I'm just missing it.
So yes, so there was one amendment you saw. The Second Amendment I actually drafted on Delegate Long's behalf. It has not come out, so therefore we can discuss this, but I think we're going to hold off on voting on it until we get the amendment.
Chair Cardin, the amendment I believe was sent out this morning.
Oh.
Yes,
It's in a follow-up email. I think around 10 o'clock or so. You should have it. It's by itself.
Great.
Okay, let me look through my email.
Yeah, let me know if you don't have it and I can send it out again.
It's pretty straightforward. It's just kind of typical language, which says this act shall be applied prospectively and shall not apply to be applicable to any pleading or action filed prior to the effective date of the act.
Okay. So let's talk about is there any questions about the amendment? Let's talk about the First Amendment, which is the one that stays the proceedings properly, right? And that was drafted by Delegate Long on behalf of the bankers. And are there any other questions or comments about that amendment? All those in favor of the amendment, raise your hands. This is, again, while it's recorded, because this is recorded, I'm not recording who's voting in favor and who's voting opposed. Okay. Anybody opposed to the amendment? All right. There is, thank you, Delegate Conaway. Got it. Is there any discussion on the amendment that makes this only prospective?
I guess I have a question. I mean,
Sure.
is that needed? Because the bill has an effective date of, I'm assuming, October 1st.
So
So
let
wouldn't
me,
we already assume that
Great.
it would apply to any pleadings filed after that date?
great question. And I actually asked the same question. So here's the scenario. This is really only a matter of for the next year or so, but let's say that there is a proceeding that has been that's being contemplated, or that has begun. Let's say it's a foreclosure that's begun, and this goes into effect, and they then say, "Oh, now the foreclosure hasn't actually happened. They've just filed some papers, but they file this in order to have the foreclosure stayed for a certain period of time." It's not clear as to whether it stays it because there hasn't been a decision on whether the foreclosure, there's just been papers filed, preliminary papers filed. And the question is, do we want to allow people to use this as a tool to delay for things that are already in the pipeline right now? And the answer is, there are some people that say, yes, we do want to use that, but I don't think that's the intent of the bill. I think the intent of the bill, and correct me if I'm wrong, Delegate Long, but the intent of the bill is to actually just improve for the future and not to mess with things that are already in the pipeline. Okay. Any other questions? Great. So all those in favor of the amendment to make it prospective? Okay, let me put it this way. Is there anybody opposed to the amendment? Great. Okay, now, I will say that I did speak with the Estates and Trusts, not the Estates and Trusts, the Elder Care section of the bar. They were supposed to have somebody on the line. Is there anybody on the line or in the waiting room coming? Morris Klein, is he here? Did he get the information? He got the information. Okay. We're gonna call the section. Delegate Long, I mean, you could stay on if you want, but I'm gonna ask us to pass this until we at least get them to find out if they intentionally didn't come onto the Zoom or they did, but let's just make sure that they have an opportunity to voice any concerns if they have them. They may be okay now with the amendments. All right. So we're going to just hold off on the vote on this for just a few minutes.
Chair, I think Delegate Long was trying to raise his hand.
Oh, sorry. I'm sorry. Delegate Long. Yes.
Thank you, Mr. Chair. Do you want me to wait just for the end of the meeting and step back to my meeting?
If you want to, I mean, it's only, yeah, if you want to remain, you could just put yourself on mute and wait and see. We're going to try and get him on as quickly as possible.
Thank you, Mr. Chair.
All right. We've already passed those two amendments, though. So now if we pass the bill, it's with the amendments. Okay. So Mr. Klein is in the waiting room. Can we get him out? Natalie. Is he in? Do we see him in or not? Oh, nope. That's Delegate Tolles.
Hi. Did you call my name? I had a WIT meeting. I'm sorry.
No. We're looking for a witness if he's available, but I think we're gonna hold off.
Oh, okay.
We're gonna go to the next one, and then when he comes in, we can return back to 359. Let's go to House Bill 528. This is the Orphans Court Judges Bill, that restriction on practicing law. Is there any comments about this bill that has come in without any opposition whatsoever? All right, I'm gonna then ask for a motion on House Bill 528.
Move favorable. Second.
Okay.
Second.
Great. Is there anybody opposed to the favorable? And I'm going to assume, because everybody's hands are very heavy today, that those are all favorable votes then from the committee.
Except
Very good.
one accused.
Excuse me, except for Delegate Conaway, who's excused.
Thank you.
Okay. Natalie, I've been told that Mr. Klein is on. Is that Oliver Slade? Is that, no?
He's on 315.
Okay. Is there somebody waiting in the waiting room by any chance? All right, I am not getting any response from anybody, so we're gonna continue on, and once we find
So,
this.
Chair, we don't have anybody by that name in the waiting room. Is it if it's under another name, have him reach out
Is
to
he under
Hunter.
another is he under another name? Can you ask
He's
him?
on the phone. Do you want me to just put him on speaker?
No. I want, if you. Okay. All right. Good. Let's go to House Bill. Let's do House Bill. What's it? Is it 1308? Is that the new one that we put on at the end, the Delegate Weibel's bill? Holly, is that the right number?
Yep, it's 1308, and it was added. And Delegate Weibel, I think, is on this call. He
Okay.
was
Yeah.
not at the hearing, so we wanted to
Right.
just loop him in.
Right. Delegate Weibel, thank you for introducing legislation. It was my understanding from a conversation very early this morning that you were considering trying to make this a local bill. However, in the interim, we found out that another county is having a similar issue. Maybe we do want to consider making this a statewide issue. You're not gonna introduce that amendment, correct?
Correct. So I offer that as a separate amendment, amendment number 1. If you chose to make it a local bill, that was the request of the committee last year. So I offered that as an amendment, so not to cloud things up. So if you all choose to make it statewide, you just wouldn't accept that amendment.
I mean, I'm not going to ask for a motion on the amendment because it's my understanding that Anne Arundel County is having the same issue, and therefore this might make sense to make it a statewide bill. Delegate Grammer.
Does anybody have a reason or justification as to why it would not be a statewide bill? Can we just suss that out real quick?
I think if Delegate Weibel was trying to explain that last year he had introduced this legislation, and the request from the committee was if we're gonna get a favorable report, it's gonna need to be local. Is that my understanding, Delegate? And
That's
therefore,
correct. Yep.
and therefore you needed you had tried to offer that amendment. It still didn't make it out in time. I don't see any other reason. There's no policy reason, as far as I know. Okay.
And I can just chime in here very quickly. Last year, Washington County, we were up against crossover, and the support was an issue in Washington County. Now, as Chair Cardin mentioned, other county is also seeing this happen. And so that was what came out at the hearing, that possibly it might be a statewide issue, not just a Washington County issue.
Right.
Now, if I may, Mr. Chair, there was also a second amendment, which was drafted by Ms. Cheney, which would add Washington County to additional language that other counties already have. I would ask that you would accept that amendment.
And can you, Holly, do we have that amendment?
I do not have that amendment.
It was offered at the hearing. I can provide that to you.
Okay, let me see if I
Email
can
it.
pull it up.
It's also on the system. It just, it adds Washington County to current language. It has Allegheny, Cecil, Charles, Dorchester, Hartford, Howard, Kent, Queen Anne, Somerset, and St. Mary's.
I can, Holly, can you indicate, it adds it to, in what respect does it add it? I'm sorry.
Hold
It's
on,
in-
I'm gonna see if I can pull it up and get it out to everybody, so just give me just a minute.
Okay, sure.
I'm not an expert on straw deeds, but I'm under the understanding after it was reviewed that this would prevent a straw deed from also being recorded in the county.
What article is it under?
It's under section 3-104B2.
Of what article?
Should be the real property article.
Okay.
Chair, I'm sorry. What's the bill number on this one again? Because it wasn't originally. on the list.
1308.
Thank you.
Chair Cardin, amendment's gonna be coming out from Hunter. He's emailing it out to everybody.
Hunter, you are exceptional. Okay. Okay. So as written, the bill basically makes it a misdemeanor and a $500 fine to record something that that is knowingly false, has knowingly false information on it, with a maximum fine of $500. And this additional amendment, which we are, which is coming up any second, will just add to the list of counties where you can't file a straw deed, which I guess is an instrument that those of us who don't practice real estate law aren't necessarily familiar with, but it adds Washington County to that list of jurisdictions that you cannot file a straw deed. Is that, and am I saying that all correctly? Delegate Weibel? As far
That
as,
is my understanding. Yes, sir. I am not an attorney.
okay. And there was no opposition from, I don't think there was any opposition at all. Let me just confirm that. There's no opposition. There was Bankers Association is favorable.
Delegate Embry has a comment.
Coming back. Yes, Delegate Embry.
I'm sorry. Can someone explain what a straw deed is? Forgive me. I just don't know what that is.
I can chime in here. So it's when two
Thanks.
deeds are filed quickly right after each other. So for example, the first from party A to B, and then they do it back B to A, and they're filed back to back, if that makes sense.
What's the purpose of doing that?
I guess it has to do with the ownership, and concealing, a lot of times concealing the true owner, because it goes from the A to the B back to the B to the A. So I guess I'm trying to think of an example, but a lot of times it's used for ownership purposes.
Okay, thank you.
Is there any understanding as to why certain counties prohibit this and other counties do not? Looks like about half prohibit it and half do not.
I don't have the background on why some counties are under this section and some are not.
In my experience, it could have been something to do with maybe an LLC would be the owner and then transferring it from maybe an LLC to an individual person. Years ago, prior to the filing fee changes for LLCs with SDAT, you might have had somebody who sold an LLC and then converted it maybe to a personal name or a different LLC. That would be the only way that I would think that would be a reason to.
I'm just trying to figure out why they would do a straw deed, though. I can understand the LLC and the limiting liability or hiding ownership, but if you do what Holly said, and you deed it to one entity and then deed it right back to the other, so that limiting exposure, I guess.
Some of it could have
Delegate Williams.
Yeah, I was gonna say, I guess, and I apologize, I had stepped away from my computer for a quick second, but I've seen situations where a property is deeded to one property. They know they're about to face foreclosure, or they're having some other situations where they are trying to circumvent what's other stuff that's going on. So they'll deed it over to another person or entity to try to forestall a foreclosure, and then file bankruptcy and then deed it back to them. I've seen those types of scenarios. But my other question that I have, I'm looking at the original text of the bill on my floor system, and it's adding a new provision to 5-106, which is fine. But then it says a prosecution for an offense under 3-104.2 of the real property article. And maybe my books are old, and maybe the Westlaw thing online is old, but I don't see 3-104.2. All I see is 3-104.1. So that was my only concern. And again,
if you look at 3-104, you got to just scroll down a little bit and it's there.
No, but that's not what it says.
No. I think that we're actually creating 304. We're creating 3-104.2.
Yeah, that's correct, Chair.
All right, sorry. Okay.
Yeah.
And Mr. Chair.
Yes, Delegate Phillips.
And I'm sorry, just kind of chiming in on the straw purchase. A straw purchase can be done for a number of reasons. I'll give you an example, one that I've been involved in. If you're attempting to consolidate a lot, let's say you're doing a development project and you may have multiple parcels, you may get a entity to acquire one of those parcels to then move into, and it would not be, from a buyer, from a one parcel owner to a straw purchaser back to that parcel owner. Is usually from a parcel owner to a straw purchaser to that third party. Often when you're doing development, let's say like a nonprofit, there may be multiple parcels. One entity then takes the title only for a moment to pass it on to that third entity. So there are a number of reasons why you might do that in addition to avoiding foreclosure. But generally, it's a matter of moving a parcel from one owner to another owner with someone in between for a number of various reasons.
Okay. Look, I don't particularly have a strong opinion. Thank you for that information, Delegate Phillips. I personally don't have a strong opinion either way, but it seems like there's a little more substance to the straw purchase amendment that maybe needs to be worked out. As opposed to the bill generally, but I don't have
Question.
Yes, Delegate Kramer.
Yeah, maybe we can ask Delegate Weibel. Everyone gets the sense that this amendment might put the bill on tilt. Delegate Weibel, are you willing to just withdraw the amendment if we're just willing to get?
I'm okay with it. Yes, thank you, Delegate. I'm okay without the amendment because actually what we're trying to do is try to create or give someone a reason not to do this practice. The guy that brought this issue to me spent $80,000 defending title to his property.
Right.
So this gives him the ability to recover those legal fees, whereas currently the law does not allow him to do that.
Thank you for that question, Delegate Brown.
Yeah, if we're withdrawing the amendment, I'll just move favorable on the bill.
Okay,
I'll
is there a second?
second.
Great.
Second.
All those in favor of the bill as not amended, unamended? Very good. Okay. Anybody opposed for the record? Great. Okay.
Thank you all. I appreciate your work on the bill.
Thank you. Okay, let's move on to the last bill on our agenda, which is House Bill 392. We have, I believe, a couple witnesses here to answer questions and to talk things through with us. We have Mr. Slade, we have Mr. Greenfield, and I believe that in the waiting room is Mr. Johnson. If he is, Natalie or Hunter, can we let him in?
He is in the waiting room. I'll make sure they let him in. And you also have an amendment for this too that was sent in your packet.
Right. So the amendment was done by Delegate Stewart. Is that correct? And Mr. Slade, are you here on behalf of Mr. Stewart? Or Delegate Stewart?
Yes, I'm here. I'm Delegate Stewart's intern. I'm here to answer any questions, and I'm happy to explain any of the amendments if that would be helpful.
Are you familiar with the amendment?
Yes.
And would you like to describe it to the, first of all, does anybody need a recall on what this legislation does? If anybody wants that, I think that everybody remembers. Okay. Can Mr. Slade, why don't you give us a rundown on what the amendment proposed by Delegate Stewart?
Absolutely. So the amendment that I believe you have in front of you is 143928. And so this amendment is mostly just to clarify that this is not to for people to like record over the phone or to bug like landlords' leasing offices. It's not anything like that. It's only for someone to be able to like go in with like their iPhone and just hit record the feature on their phone without notifying the landlord that they are doing so while conducting fair housing testing. And so that is the main purpose of that amendment. And there's another part of that amendment, that the first paragraph up there with the wire and electronic, that's what that does. And then the second part of the amendment is stating that this can only be used, these recordings can only be used to enforce fair housing law from the federal, local, or state level, and cannot be used in any other criminal cases or civil. Yeah.
All right. Delegate Airkin.
Thanks. So, okay, so that last amendment sort of fixes some of the stuff that I was kind of worried about, but I'm trying to think in my head, like, if some kind of crime does occur at one of these appointments, we have this recording, we now can't use it. Aren't people just going to come back next year and say, this is such a travesty, we had this whole thing recorded, we couldn't use it? Like, I just feel like this is the sort of beginning of completely the deterioration of the all-party consent rule in Maryland, which many of us, some of us love dearly and don't want to see change. So I'm just generally uncomfortable with the entire concept of picking away at this because it does protect people, I think.
I was hoping to stay on the amendment right now, but I understand that there's issues with the bill, and the bill may have, but I think we should just at least figure out the amendment as first. I think the amendment does narrow it. Is that the intent of the amendment? And
yes, that's absolutely the intent
for very specific purposes.
Okay. I don't see the physical copy of the amendment.
Yeah. Could you share it or resend it?
Yes. We will.
Yes.
Natalie, can you share the amendment? Is that what you were going to ask Delegate Williams as well?
She's going to screen share it, Chair.
No, I have the amendment. I was just going to say I actually had concerns with the bill prior to the amendment. And I actually like the amendment because I think it does properly narrow the scope and limit it to just oral communication and removes the wire and electronic communication. So I am, or not, yeah, leaves in, yeah, remove, just adds in the oral. And so I'm fine with the amendment, actually. I think it makes the bill better.
All right, here's the amendment. Thank you. You can pull it down, great. Keep going down a little bit further. Interception under the subparagraph of. Is that the entire amendment? Is number 2? Yeah.
Yes, Mr. Chair, it's the entire amendment.
Okay. All right. Is there? Yes, Delegate Erican.
So this doesn't do what I think it needed to do. It doesn't, it only says unrelated criminal proceedings. So it would need to include civil as well. If it wants to do what was stated previously. If you're talking to us, we can't hear you.
Sorry about that. So because what was stated by Mr. Now I forgot Oliver. Apologize, I forgot your last name already. Is that it cannot be used for any other proceedings, regardless whether they're criminal or not, right? It can only be used for the purposes of enforcing federal, state, and local fair housing.
Yeah. Let me double check on that real quick. I am not entirely sure whether it's supposed to be criminal, or whether it's supposed to be civil as well as criminal. It's very well the case that fair housing laws only apply to criminal cases.
Yeah, except, I mean, I think that the point is stated that it's not a question of what fair housing is, it's a question of what this recording can be used for. Right? I think that's what Delegate Erican was trying to say. Yes, Delegate Robertson.
Let me, so I kind of going down the civil process, and so making sure I'm understanding this. You're saying that for anything outside of the fair housing issues, the individual could not be, I guess, sued, is what you're getting to, Delegate Erican? For anything that's unrelated, and I'm just trying to figure out what that could entail.
Well, Delegate Erican's left, but I mean, so Delegate Williams, yes.
I was just going to try to answer Delegate Roberson's question. In the sense, it's not necessarily be sued, but just if there was a criminal proceeding or a civil lawsuit, I think is what Delegate Erican was looking for, then the recording could not be admissible in that other proceeding during that court hearing.
Got it. Thank you.
Mm-hmm.
Right. So let's say that there's, for example, a protective order, a peace order, and there was something that was said in that conversation that could be used for it. That's a civil proceeding. And the question is could it be admissible or not? I think that's an example, something that's unrelated to a criminal matter. Okay, Delegate Grammer was first, I think. And then
Thank you, Mr. Chair. So this kind of speaks to my overall bigger concerns of the bill. We have 2 other wiretapping bills this year, and this kind of stirs the waters a little bit. And the bigger concern I have with the bill is it's just a little police statey. We're starting to kind of pick these situations where, end this situation. We want to allow it for this. I just don't. I think Delegate Archon's right. If we want to really amend it to guard against what we needed to amend, we should probably change the amendment to specifically say civil cases as well. But I just don't feel great about the bill, amended or not.
Okay. Delegate Phillips, you're next.
So I would suggest, and I'm going to say a me too on adding civil. And Mr. Chair, you and I spoke about this. My sense is this is operating very similar. This is getting around the idea of having some type of a warrant before going in and taking this action. So in my mind, before a taping should occur, there should be some predicate or some reasonable suspicion of wrongdoing. And at that point, and I'm not suggesting that this needs to go before a judge, but some type of acknowledgement that there is some suspicion of wrongdoing, that would be an additional amendment to this, but some type of suspicion of wrongdoing before, you would allow the investigator to go in and record. That would be my thought. And I think that would protect, it would not suggest that we're now saying that you could do a third party recording in and of itself. It would suggest that there is a reasonable suspicion, and that would get you to the place where you could do a recording.
Okay, Delegate, I think we have Delegate Williams next, and then Delegate Embry. I have to turn my sound up when Delegate Williams talks because she's so soft.
I've never been called soft-spoken before. This is
But
fun.
your microphone is soft.
Oh, okay. No, actually, I think Delegate Phillips kind of addressed what I was kind of going to get to as kind of the other concern, but I see Mr. Slade is back, so I don't know if he has an answer to our civil criminal question, but I think Delegate Phillips brings up a good point that typically with any wiretap or oral communication being admissible in any type of proceeding, there's a warrant involved. And so I don't know if Mr. Slade also has a question, has an answer towards that concern.
We'll go to Mr. Slade first, and then we'll go back to Delegate Embry.
I'm working on an answer to the civil part of this, but Delegate Phillips, your point, we have that amendment drafted to create like a prior encounter. And so fair housing testers could only record if they have a reasonable suspicion, and it would not require them to go to a judge, but they would have to have a documented previous suspicion that a landlord or a leasing agent is discriminating. And then from there, they could record. And I can send that over to you right now for you all to have a look at.
I'm gonna go to Delegate Embry, and then I think that Aaron Greenfield has a comment. Go ahead.
Thank you. And I have a comment and then a question. I do like the bill. I think it is, as long as it's restricted and not being usable in a criminal proceeding, I think that protects against Fourth Amendment concerns. And also, I just want to remind everyone that warrants are not required when law enforcement records without consent. So warrants are not required in all situations under current law. But the question is, I just want to make sure, and this question is for Mr. Slade, that you're sure that oral communication is the correct definition, and that recording a phone conversation, that is entirely captured within the oral communication definition and does not also encompass electronic. And because is my understanding that your amendment is stripping out wire and electronic, is that correct?
Yeah, that is correct. And those definitions are, yeah.
But have you consulted, I don't know, somewhat the Attorney General's office, just to make sure oral communication does capture the recording of a cell phone conversation? You may be right. I just want to make sure. That's all.
I'm not sure. I will.
Okay.
So good. Okay. Aaron, you have a comment, and then I'm gonna make a suggestion, but go ahead.
Yeah, and I have Jim Johnson, who's a real subject matter expert, the former Baltimore County Police Chief, on the line as well, that can talk about some of the technical areas. But keep in mind that this is unprecedented in a two-party consent state. What you're doing is you're poking holes in the two-party consent standards. Unprecedented. And you're allowing a nonprofit association or organization to do this without any safeguards in place. And my understanding from the testimony of the Attorney General's office is that this is largely civil, but there is a small slice of the fair housing law that is criminal as well. And I've got to tell you, the housing providers have a reasonable expectation of privacy. If you start poking holes here, what's next? Are you going to have to journalists, legislators, bankers? Where are we going to draw the line? And I think Mr. Johnson can speak to the custody concerns, the training concerns of those nonprofit organizations that you're empowering in this scenario. This is incredibly significant. And I caution the subcommittee, Mr. Chairman, to make this decision because it is unlike anything else this I might suggest the subcommittee would do, even with the safeguards that are suggested in the amendment.
I'm gonna continue this conversation. Let's go Delegate Grammer. Oh, wait here, let me just, let's put some guardrails. I think we are going to continue discussing this. We're gonna take the amendment back, see whether it needs to be, the amendment needs to be amended, talk to whether we have to talk to Delegate Stewart, and we're not gonna be voting on this today. I think we're gonna, but I do think that this conversation is very informative and can help us figure out if there's any different directions we're going to need to go. So, but I want to continue this for a few more minutes. We're going to go for another 10 minutes. We do have to get back to our, I believe that we have Mr. N and Mr. Klein for the previous bill that we didn't vote on. So I'm going to say we're going to do this for another 5 minutes, and then we're going to terminate this conversation, go back, decide whether we're voting on the next one, the last one, and then we're going to end. Give everybody some time for lunch. Go ahead, Delegate Grammer.
Thank you, Mr. Chair. I just wanted to say I agree very much with what Delegate Phillips mentioned about some kind of qualification. I will say that, you know, some of the other standards that have been used in situations like this are like the reasonable suspicion. I think that's a really low bar for this particular application. I mean, the nature of the nonprofit, they could say, well, yeah, we suspected that there was discrimination in this case, so we unilaterally record everybody. So I agree with Delegate Phillips in principle. I do think if we decide to move in that direction, there should be a little bit of a higher standard that we use to kind of qualify those cases, because if we use the reasonable suspicion, frankly, it's going to be every single case and there's going to be no protection at all.
Great, thank you for that. We're going to try and go. I know that Chief Johnson wants to speak, but why don't we go to Delegate Aricam first, and then we'll go to
I don't need to talk. Grammar just said everything I was thinking.
Okay, Mr. Johnson, you want to?
Well, good afternoon. I apologize for not being on screen. I'm trying to do this on a cell phone. Just to clear things up here, there's two separate issues when you talk about where these leasing agents may be. It could be by telephone or it could be in person. Both these circumstances, you'll create a situation where you could be recording people who are not party to the conversation. It requires an understanding how these offices are laid out, for example. There could be 3 to 5 potential tenants applying for an apartment with 3 to 5 different leasing agents who may not be party to the conversation that's being recorded. So I think that needs to be considered. While it is true that a warrant is not needed for certain enumerated crimes, all right, reasonable suspicion is. I can't, as a law enforcement officer, simply begin to record somebody because I have a speculative possibility that the person is or may commit a crime. And lastly, I don't see how these amendments really address some of the issues we brought up previously regarding chain of custody, evidence safekeeping that will be used in some punitive manner as, you know, a case progresses. But really think about that issue for a minute. When I go into a leasing office with the cell phone and I'm recording that interaction, I'm also recording people who are not party to that conversation. How do you fix that? That's my 2 cents today.
Can I just ask, has there been any discussion about AI and the the impact of possibly tampering with and being able, and I mean, you had mentioned, or I think that Aaron or you, somebody had mentioned training. I want to make sure if we're going in this direction, we need to be able to talk about whether, you know, what happens if training is not done right, or can we even oversee the training properly and that. So, and I know that Mr. Slade's gonna speak after Mr. Johnson.
Look, I think it's an excellent point to raise AI, particularly in this time and age here. Law enforcement are governed by Maryland Correctional Training Commission. They're standardized training programs. And what I heard on the House side was that, depending upon the agency, they have different training programs, different requirements. I can tell you they don't have the ability to keep these pieces of evidence as law enforcement does. It's very costly. It's very human resource intensive. So, you know, again, I think that really should not be glossed over, how these things are kept, how they can be manipulated in this new age of AI.
All right. So last word to Mr. Slade on behalf of Delegate Stewart. Go ahead.
Yeah, I'll be brief. First of all, I just want to say thank you all so much for letting me speak today. And to Delegate Embry, to your question, oral communication is the correct language for the bill. I've just sent over the amendment that includes all the prior interaction to your office, Chair Cardin. So Delegate Grammer and Delegate Phillips, especially, I know you all were interested in that. If you all want to take a look at that. And to Mr. Greenfeld's point, these cases are always civil. There was some confusion in the Senate hearing about it potentially being the occasional criminal case, but fair housing cases are always brought as civil cases in practice. So the case of criminal case is not really a concern. And also, I just want to say, like Delegate Stewart is very much, this is in the hands of the committee now. And he really doesn't want to let the good enough get, the perfect get in the way of the good enough with this bill. So it's in your hands, and I want to thank you for all your work on it.
Thank you very much. Okay, so we're gonna look at some of this amendment language. Maybe Delegate Phillips, you and I can sit down and see if we can, if there's language that we're interested in or that you're interested in, and we can talk about it. Do appreciate everybody coming in. We can, with the Mr. Slade, Mr. Greenfield, Mr. Johnson, we may need you next week. We'll see. Any other comments for the good before we go back to House Bill
359.
Excuse me, 359, right? 359. Great. Do we have Bob Benton and Morris Klein on the
Yep,
line?
we're letting them in right now.
Awesome. You guys are fantastic. All right. So,
Chair, can we just see, we have an iPad. Is that Mr. Enton? I'm just trying to figure out who that person is.
probably Mr. Anton. Let me find out. Let me see. I am getting on an iPad. Okay. Mr. Klein, thank you very much for being here. I asked originally asked the Estates and Trust section, but apparently the Elder Care section is really the right section to be grappling with this. And Morris Klein is the legislative, I guess, committee
Chair of the
person.
legislative committee.
Chair of the legislative committee for the Elder Care section of the bar. We want to, so I don't know how privy you were to the amendments to this bill, but I know that we've passed the amendments. The bill is now on the floor. I wanted to give the State Bar the opportunity to express concerns that I think you have before we go forward.
Okay, well, thank you very much, Mr. Chair and members of the, I guess it's the subcommittee. My name is Morris Klein. As just mentioned, I am the legislative chair of the Maryland State Bar. Elder Law and Disability section. And I've received permission from the State Bar to speak on behalf of the section. I also have been authorized by the Maryland chapter of the National Academy of Elder Law Attorneys, Maryland DC chapter, to also speak on their behalf. The Elder Law and Disability Rights section is an attorney organization whose 500 plus members represent primarily senior and disabled adults. Many of our members' practice includes guardianship proceedings, either representing petitions or alleged disabled persons. I personally have represented petitioners, both individuals and a hospital, in seeking guardianship. I've also represented individuals who are alleged disabled persons subject to a guardianship. In my hat as representing the hospital, I am sympathetic to the hospital's desire to discharge a patient promptly to a
Before
setting.
we go any further, Mr. Klein, I just want to make sure we are on House Bill 359, which is Delegate Long's bill. And I think you may be on the Vice Chair's bill. This is a bill that requires automatic stay of specified civil actions and proceedings when the petition for guardianship of the property of an alleged disabled person is filed. The stay remains in effect until the guardian is appointed or the petition is denied. So I apologize if you got information about the wrong bill, but I want to make sure that, and if you're not able to comment on this bill,
let me quickly look up. What's the bill number?
It's House Bill 359.
Well, unfortunately, I only have permission from the MSBA to speak on behalf of House Bill 698, which was the bill I was informed I was supposed to speak about. So I apologize.
Okay. All right. Well then, and we have information from Mr. Enton's group, the bankers, that they're okay as amended.
Right.
So at this point, yes, Delegate Embry.
I apologize, and I hate to slow this down, but is it possible for Mr. Klein to review the bill and get back to us in short order?
Yeah, I mean, I would
And the
be
amendments?
speaking for myself and the NAILA chapter, but not the MSBA, because I haven't run this particular bill through their vetting process.
I have no problem with that. I think we can take it up in short order once we have, and we can get in, especially if it's a positive review, some sort of written affirmation or assent would be sufficient for us to be able to pick it up. Delegate Williams. You're muted still.
I was about to move the bill favorably. I mean, I understand that we're looking for the input from the Bar Association section, and I appreciate that. But I know this bill was filed a while ago, and just my opinion, if they had an interest in it, they should have chimed in at that point. I don't remember them submitting anything favorable or unfavorable otherwise prior to the bill hearing. And so everybody else is favorable with the amendments that the delegate has put forth, including the bankers at this point. So I don't know if it's necessary for us to delay.
I would
And
second.
I would second that.
Yeah.
Okay, who was that who just seconded it? Delegate
This is Delegate Phillips.
Delegate Phillips. Okay. All right. Then with that, there's been a motion and a second. Mr. Klein, should we pass this, I would recommend you guys take a look at it as it goes over to the Senate.
Okay, am I still needed for the other bill, or?
No, we've withdrawn. The other bill's been withdrawn.
Okay, all right,
All right.
well, I apologize for the confusion, but.
No, maybe it's probably not your fault. Okay.
All right.
I would like to take up the motion favorable. All those in favor of the favorable, raise your hand. 1, 2, 3, 4, 5. Is there any unfavorables? Mazel tov, Delegate Long. Okay. Any other comments for the good of the group before we let you guys go to lunch? 12:30 on the dot. It's wonderful.
Great meeting, Mr. Chair.
Thank you.